thank you to Mark Wealth Management for their sponsorship of the event. We had obviously hoped to do this in person, but yet again, it was not to be. So hopefully next year we'll be able to do it in person and get together. So for those of you that are joining us for the first time tonight and don't know much about BACFI, BACFI are a specialist bar association, and we provide support and promotion of the interests of the employed bar. So please do take a look at the website. The details are on the handout that you should all have as well. I think Sandra sent that around. But on the website, you'll find lots more information, including how to become a member of BACFI. We'd love you to join if you're not already, and our contact details. So please do get in touch. The Denning Lecture has been an annual event as the Denning Lecture since 1981. And that was in honour of the late Lord Denning. But even before that, starting in 1975, would you believe, BACFI has been organising annual lectures, all of which have been delivered by an eminent lawyer of the time. And tonight we're honoured and extremely grateful to Amanda Pinto QC for agreeing to deliver this year's lecture, CEOs, Crimes and Corporate Responsibility, close to all our hearts, I think, at the Employed Bar. So it should be very interesting. And to Patrick Rappo, who's going to lead the discussion following the lecture. So I'm not going to go into great detail because I know you've got all of the information already, but Amanda is currently in practice at 33 Chancery Lane and is specialising in, again, subjects close to many of our hearts: fraud, corporate crime, bribery, money laundering, things that make us all shudder as general counsels and employed barristers. As many of you know, Amanda was chair of the Bar Council in 2020 and is a bencher at Middle Temple and has been nominated and shortlisted for many awards. And in 2021 was appointed a member of the panel of recognised international market experts in finance. And Patrick, I think most of you probably know Patrick as well, a partner in the London office at DLA Piper, co-chair of the Global Investigations and Compliance Group. Patrick represents companies and individuals across lots of high-risk sectors and jurisdictions and has been involved with a number of high-profile investigations and prosecutions. Patrick has previously led the bribery and corruption divisions at the Serious Fraud Office and has been a specialist criminal law advocate at 9 Bedford Row, currently a bencher at Grays, an advocacy trainer for Middle Temple and a pupil supervisor and trustee of the Fraud Advisory Panel. So I want to encourage questions in the discussion that we're going to have following Amanda's lecture. Lots of participation would be fantastic. I will do my best to keep my eye on the chat, but it's not my strong point, so I'm sure Sandra's going to try and help me with that. And without further ado, I'm going to hand over to Amanda and Patrick. Thank you.
Hopefully the mute button is now off and you can hear us. I'm not sure if Sandra can work her magic and put Amanda and myself center screen. We're at the DLA offices here, and I think it would probably assist in that regard if people who aren't speaking turn their cameras off as well as put themselves on mute, and then I think that might automatically make us appear center of everybody's screens. But while people are doing that, may I thank everybody for attending and for our sponsors, and we've got a great turnout this evening, and that's in no small part due to our speaker this evening. So without much further ado, Norman, if you're able to switch your video off, that'd be fantastic, and then hopefully Sandra will be able to put Amanda and myself center screen, and I can hand over to Amanda and then she can start this evening's proceedings. I understand it'll take about half an hour or so, and then I will ask her some, hopefully not too cutting and deep questions, and then other people, please, during the course of the lecture, please submit your questions via the Q&A box, and then Gaynor will be able to moderate those from the sort of half-hour mark onwards. So without any further ado, Amanda, over to you.
Thank you very much, Patrick. Well, it's a real pleasure to be here this evening and a double honour to be delivering this lecture. First, because I am a huge supporter of BACFI, and secondly, because it is a privilege to be delivering a Denning lecture following such illustrious predecessors. Bearing in mind the upheaval of the last 2 years, I wondered what topic I should address in 2021. Of the many things that the past few years has changed, the burgeoning of corporate responsibility is a thread that many BACFI members doubtless have to consider when advising their CEOs, boards or clients. That corporate crime is now the subject of public debate reflects an increasing anxiety about public safety, corporate governance, and possibly a lack of trust in companies. Regulatory regimes are rife in modern British life. We may consider current corporate responsibilities to be more onerous than before, but a glimpse at history makes one wonder whether accountability has really changed that much. So this evening I'll be exploring the extent to which changes to corporate criminal law, both for the company and the individual board members, have and should have altered the landscape of corporate responsibility. And to begin with, I thought a little history might not go amiss. Let us go back a century, long after the law of England and Wales first acknowledged that legal persons have enforceable rights and responsibilities. Just short of 110 years ago, on Sunday, April the 14th, 1912, a dinner was held in the first-class restaurant of RMS Titanic in honor of the captain, Edward J. Smith. At 9 p.m. New York time, Captain Smith excused himself and went up to the bridge. During the day, warnings had been received of ice in the region of the Atlantic in which the ship was sailing. Captain Smith ordered a sharp lookout to be kept and then retired for the night. And he must have done it very quickly because at 9:05, a message was received from SS California. "We are stopped and surrounded by ice." To which the radio operator of the Titanic replied, "Keep out, I'm busy." The California's warning was never passed on to the bridge. That Sunday night was clear but moonless, and at about 11:30 p.m. the lookout, Fred Fleet, high up in the crow's nest, noticed a slight haze in the distance. He had not been provided with binoculars to help him spot icebergs. He later gave evidence to the Wreck Commissioners Court that had his employer followed its normal practice and provided them, the disaster would have been averted. His alarm to the bridge, "Iceberg right ahead," came too late for the ship to change course. Within seconds, the Titanic had scraped alongside an iceberg which tore a gaping hole on the starboard side below the waterline. Of the 2,201 passengers and crew, only 711 survived. Huge loss of life was inevitable because there were only sufficient lifeboats for 1,178 people, and of the lifeboats launched, and not all were, few were filled to capacity. The Titanic was the flagship of the White Star Line, whose managing director, Joseph Ismay, was on board and survived the wreck. It was generally suspected that Ismay and the board of the company wanted the Titanic to beat the transatlantic crossing record. Despite the Wreck Commissioner finding that the loss of the ship was due to collision with an iceberg brought about by the excessive speed at which the ship was being navigated, the court did not blame White Star Line for permitting the reckless practice of sailing at speed near ice, nor did it blame Captain Smith. The Titanic disaster claimed 1,490 lives. And although the White Star Line paid out more than $2.5 million in civil settlements and cases, no one was ever prosecuted. What lessons were learned is hard to say. 75 years later, and little had changed. In March 1987, the Herald of Free Enterprise, a cross-channel vehicle ferry under the command of Captain Leary, sailed out of the harbour at Zeebrugge, with her bow doors open, trimmed by the head, that means with her nose down, with a light breeze and very little swell. Within a few minutes, the Herald had accelerated from 14 up to 18 knots. And at 18:24, a steward heard water on the stairs. At 18:28, still close to the land, the ship lurched 30 degrees to port and began to capsize. By 18:30, it had capsized in shallow water 150 passengers and 38 members of the crew drowned. This time, the formal investigation into the disaster put the blame for it squarely with the company. Mr. Justice Sheen stating, "At first sight, the faults that led to this disaster were errors of omission on the part of the master, the chief officer, and the assistant boatswain, and also by the failure of Captain Kirby to issue and enforce clear orders. But a full investigation into the circumstances of the disaster leads inexorably to the conclusion that the underlying or cardinal faults lay higher up in the company. All concerned in the management, from the members of the board down to the junior superintendents, were guilty of fault. From top to bottom, the body corporate was infected by the disease of sloppiness. And yet the prosecution of that company was unsuccessful. The identification doctrine that a corporation can only be liable for a crime when a person who is the directing mind and will of the company does the necessary acts with the necessary state of mind as the company has proved time and again too narrow a method for the successful prosecution of corporates, particularly large ones. The doctrine of identification was articulated, as I'm sure you all know, by the House of Lords in Tesco and the Trust. Despite being 50-year-old this year, decided in a completely different era in terms of accountability, human rights and corporate governance, Tesco and Natras continues to be the lodestone for interpreting corporate criminal liability. And most recently, it was explained in SFO and Barclays PLC in the prosecution of Barclays and senior bank executives, including 2 directors, in respect of capital raisings to support the bank following the banking crisis in 2008. The question was whether the allegedly dishonest acts and state of mind of 4 very senior executives could be attributed to the bank, rendering it criminally liable. In other words, they were acting as the directing mind and will of Barclays. The Serious Fraud Office alleged that the 4 men secretly agreed with various Qatari entities to give them a higher commission and greater discount than was being offered or disclosed to other investors, and that they concealed the true position from the board. The first challenge was to the criminal liability of Barclays at all. In the Crown Court, the judge, Mr. Justice J, concluded that none of the executives were the directing mind and will of Barclays. The Constitution clearly stated that it was the board that had authority to exercise all powers of the company. Subject to express delegation that was absent on the evidence, the directing mind and will remained the board. The judge accepted that the Fraud Act 2006's purpose was to prevent or deter fraud and that it applied to companies. He rejected the need for a special rule of attribution because it was possible on appropriate facts for the Fraud Act to apply to a company using the ordinary rule of attribution, the doctrine of identification. When considering an application for a voluntary bill to indict the companies again, Lord Justice Davis set out the principles that currently apply to corporate criminal liability. And they include that Tesco and Natras represents the law, that there is no principle of vicarious liability in crime, unlike civil law, that the knowledge and approval of a single director is not necessarily and for all purposes to be regarded as the knowledge and approval of the board of directors, and therefore of the company, and that companies may delegate their powers and responsibilities to an individual or a group of individuals, and then their acts and knowledge would attach to the company. All these principles must be applied to the facts. If a wider approach was considered necessary, the legislature must change the law. Although Barclays was determined in 2018, because of the subsequent prosecution of senior executives, it only became public last year. I pause to observe that this in itself may demonstrate a problem with the 2-pronged approach to prosecution of companies and individuals often taken at the moment. But let's go back for a moment to those cases involving the loss of many lives. Between the Herald of Free Enterprise prosecution and a change in the law, several manslaughter prosecutions for rail disasters failed. But, and it is an important but, every company had pleaded guilty to Health and Safety at Work Act 1974 offences, and each was fined substantial sums. This was apparently not enough to assuage public opprobrium. Political parties of every hue promised change in their manifestos, election after election. Only a conviction spelling out that an unlawful death had resulted from the corporate's failings was apparently sufficient. It took the enactment of the Corporate Manslaughter and Corporate Homicide Act 2007 for corporate prosecutions of manslaughter for all but the smallest companies to be viable. At its most basic, the enactment of the Corporate Manslaughter and Corporate Homicide Act 2007 was an answer to the question, should corporations continue to be treated as if they are humans, or do complex, devolved and multinational corporations require a different approach? That different approach has been creeping into the statute book. Parliament has been driven to legislate in respect of specific corporate crimes for criminal failings in corporate arrangements. For example, in order to comply with our OECD international obligations concerning anti-corruption, the Bribery Act 2010 was passed. It was after the implementation of that statute, and specifically the Section 7 failing to prevent bribery offence, in force following publication of the statutory guidance in July 2011, that successful prosecutions or deferred prosecution agreements against companies have been seen in any numbers. Another example of a reactive corporate offence followed the Panama Papers scandal in April 2016. It was estimated that the Exchequer lost £4.4 billion in a single year from unpaid tax. Something had to be done. The answer Parliament chose was to introduce corporate offences of failure to prevent facilitation of tax evasion in the Criminal Finances Act 2017. That statute requires companies to put in place reasonable procedures to prevent those providing services for or on its behalf from deliberately and dishonestly facilitating tax evasion. The statutory defence, which the corporate must prove, of putting in place reasonable procedures to prevent the offence being committed is similar, but not identical to that in Section 7 of the Bribery Act 2010, which does not use the term reasonable, but adequate procedures. However, in the Bribery Act Post-Legislative Scrutiny Report of 2019, the House of Lords Committee suggested there was no difference between the two, and in the context of the Bribery Act, adequate procedures must mean reasonable procedures. Legislative change has been slow, and as these two examples demonstrate, piecemeal. The fact that the executive is yet again considering different models for corporate liability for economic crime is another illustration of this disjointed approach. To my mind, it is unsatisfactory for the law to develop in this way when it affects so much of daily life. Most companies are already regulated in some way in their specific area of business, or perhaps by the Health and Safety at Work Act, a vast swathe of businesses by money laundering requirements under the Proceeds of Crime Act 2002 frameworks, financial companies by the FCA, and many businesses by trading standards, to name but a few. And rightly so. If a corporation chooses to enter a particular sphere of business, public protection and fair competition require minimum standards, especially so when running or owning the businesses are opaque due to the corporate structure. But is it the job of the criminal law to change ethical mores? In 2014, reacting to the accusation that there had been very few prosecutions since the Bribery Act came into force, the Serious Fraud Office described it as representing a major commitment to ethical corporate culture. Whether that is true is difficult to gauge with confidence. and published HMRC answers to Freedom of Information requests in May 2021 reveals that since the 2007 statute came into force, not a single charge has been laid of failure to prevent facilitation of tax evasion offences, let alone a prosecution brought. Does that make the legislation a success or not? Does it indicate a change in corporate culture for the better? Evidence is hard to gather, and frankly, it's difficult to assess. What one can say is that business needs certainty to survive, and if the law applicable to its operations are unclear or at odds with each other, decent businesses and boards doing their best to comply with their obligations will falter and suffer. That is why this parliamentary approach, enacting reactive and fragmentary corporate offences in the recent past, is, in my view, flawed. What should we actually be aiming to achieve? Extending criminal liability, putting in place more regulation, or nothing at all? It is worth noting that in the government's response to the Corporate Liability for Economic Crime Call for Evidence, published in November last year, just over half of respondents did not believe that the existing criminal and regulatory framework provided sufficient deterrence for corporate misconduct. In other words, though, almost half were satisfied that it did. It is unsurprising then that the Minister found no conclusive evidence base on which to justify reform, despite it raising important questions about the doctrine of identification. More surprisingly, a response by government departments, regulators, prosecutors, and law enforcement agencies also proved inconclusive. And that is no doubt how the Law Commission came to be considering whether the identification doctrine needs to be overhauled and replaced, or whether in fact it strikes, if not the right note, then the least worst note for corporate criminal responsibility and liability. And if it is to be replaced, should expansion of the failing to prevent model be adopted, or is regulation or civil penalties the answer? None is straightforward. In a commercial context, bribery, tax evasion, and fraud are all economic offences which focus on a corporation's benefit from the wrongdoing of associated individuals, whether in pursuit of contractual or commercial advantage or tax limitation. As each is intended for corporate gain, a consistent framework for holding corporations liable is attractive and in the public interest. No doubt to the frustration of business CEOs and their legal advisors, the tests for and defences in the existing failing to prevent offences are different. Whereas large corporate entities can pour resources into corporate governance, it's unhelpful to business, I suggest, particularly small and medium-sized enterprises, to impose extra burdens on the organisation of business by the imposition of different requirements depending on the statutory crime. If failing to prevent economic crime is more widely applied in the interests of good corporate governance, consistency in the formulation of criminal liability and of approach is vital. But in practice, it is difficult to apply, particularly where economic loss involves the company as a victim. Should the corporate be criminally liable for a rogue director's conduct from which it may itself suffer? Which economic crimes should any failing to prevent offences attach to? We need hardly remind ourselves that we are only talking about criminal liability, so the civil and regulatory consequences for the company of those acting in or for it remain the corporate's responsibility, regardless of the formulation of the criminal law. At the same time that the limitations on the identification doctrine have been explored by academics, government, and the legal community, corporate criminal outcomes have been changing in another way. In 2013, Section 45 and Schedule 17 of the Crime and Courts Act introduced deferred prosecution agreements, DPAs, to the UK. DPAs, an agreement between a prosecutor and a company facing prosecution for certain economic or financial offences, have had an extraordinary effect on the prosecution not just of companies, but of directors, senior managers and employees of the company, and not always as the government or prosecuting authorities might have predicted. According to the DPA Code of Practice agreed by the Serious Fraud Office and the Crown Prosecution Service, a DPA is a viable disposal as long as there is a reasonable suspicion based upon some admissible evidence the company has committed the offence and there are reasonable grounds for believing that a continued investigation would provide further admissible evidence within a reasonable period of time, so that all the evidence together would be capable of establishing a realistic prospect of conviction in accordance with the full code test. It can immediately be seen that the evidential test is lower than the one required to prosecute a case. By entering into a DPA, both the prosecutor and the company benefit. The prosecuting authority reduces the resources necessary to investigate and prosecute a company and enables it to agree a financial penalty, disgorgement of profit and its own costs, to its own financial advantage as well. And the company benefits from far more control over the process, its reputational risk and the ultimate outcome, including its market position and its ability to bid for future contracts. Far greater control than it would have had it been prosecuted. Overseen by the court, but on the basis of a statement of facts agreed between the prosecutor and the company, which the judge has no real opportunity to explore, it is in the interests of both parties to the agreement to present a united front to the court. DPAs had a slow start, as one might expect, but in the last couple of years, more have been agreed and they have evolved. Originally, the Serious Fraud Office said that a self-report was vital. Now it's optional. What started as a maximum of a 30% discount is now routinely at 50%, even where there's no initial self-report. And this year, a DPA between Amick Foster Wheeler Energy Limited, AFWEL, and the Serious Fraud Office was endorsed by the court as being in the interests of justice and the public. It tells an interesting tale of the current position of DPAs. It was agreed in respect of 10 offences of corruption, including a Section 7 failing to prevent bribery offence, covering 18 years of offending across 5 continents. Although an internal investigation uncovering corruption was reported to their board in 2007 to 2009, nothing was done to report the conduct to the authorities. Even this did not prevent DPA being the appropriate outcome. The court held a DPA was in the public interest. What makes this DPA all the more fascinating is that the parent company of AFWEL, John Wood Group plc, undertook to be responsible for paying the penalties and for the performance of AFWEL's obligations under the DPA, even though it was described as twice removed from the offending. In other words, a company that had done nothing wrong itself would and could ultimately carry the can for its subsidiaries' criminal conduct, all of which occurred before it bought it and of which it was unaware when it bought it. Is this really where and how we want our criminal law to operate? And what of the CEO and board members? Giving judgment endorsing the AFWEL DPA, Lord Justice Edis said this: "In my judgment, the proper course for it, the board, to have adopted in 2007-2009, not as a matter of legal duty, but as a matter of ethical corporate governance, was to report the known facts to the Serious Fraud Office. I accept that there was no legal requirement to report suspected crime to the authorities, but there is a moral duty on all citizens in this respect, which extends at least equally to corporations. Although one can well sympathise with the conundrum the court faced, it is questionable whether this is correct as a matter of law. It is the duty of every director of a company to promote the success of the company according to Section 172 of the Companies Act 2006. Subsection 1 reads, "A director of a company must act in the way he considers in good faith would be most likely to promote the success of the company for the benefit of its members as a whole, and in doing so have regard, amongst other matters, to the likely consequences of any decision in the long term, the interests of the company's employees, the need to foster the company's business relationships with suppliers, customers, and others, the impact of the company's operations on the community and the environment, the desirability of the company maintaining a reputation for high standards of business conduct, and the need to act fairly as between members of the company." Ethics or morals do not come into it. In the United Kingdom, DPAs are not available for individuals, and individuals have no standing or ability to intervene in the agreement of a DPA. Whether named in the agreed statement of facts, as they originally were, or supposedly unidentifiable, as the practice has now become, those against whom there appears to be evidence of commission of a crime in the corporate's internal investigation or the prosecutor's examination of the facts are entirely left out of the process. That process, as we have seen, may be driven by business imperatives that are at odds with likely outcomes in court. The last few DPAs and prosecutions of companies such as Barclays have been followed by the acquittal of the individuals subsequently prosecuted. This does nothing legally to undermine the standing of the DPA with the corporate, endorsed by the court, but it appears odd at best and contradictory at worst to the public. And either way, it demonstrates a profound difference in approach from traditional prosecuting. It is unsurprising that there are difficulties for the prosecutor pursuing individuals when the foundation of a DPA is on a lesser and different evidential test, with a party engaged in obtaining a cooperative result rather than an adversarial process, one in which it agrees matters on a pragmatic rather than an evidential basis. What is in the interests of the business and shareholders of the company may very well not be what is in the interests of those senior managers who have acted for the company, or indeed the company itself, many years before. So how should the CEO and those advising her or him approach individual liability? One thing is clear. Despite the fact that a DPA may have provided an evidential foundation, often skewed for the reasons we have noted, it is inadmissible in a subsequent criminal trial of those who are not party to its agreement. The Law Commission was recently tasked with considering questions such as which principles should govern the criminal liability of an individual director for the actions of corporate bodies. Were statutory consent, connivance, or neglect provisions necessary? Or is the general law of secondary liability sufficient to prosecute directors where they bear some responsibility for a company's criminal liability and conduct? Although there are numerous provisions extending liability to officers or others whose consent, connivance, or neglect leads to corporate crimes, they are not invoked often. Conviction is dependent on proof of an offence against the corporate. Easy to do in a regulatory field where strict liability is the norm, but far harder where the identification principle is the route to proof. In my opinion, where there is adequate regulatory regime to address individual conduct that falls below that required in business and risks the protection of the public, but falls short of the standards we set for our criminal law, a regulatory or civil disposal should be sufficient. Directors' disqualification proceedings in the Chancery Division provide another example of civil protective measures. So, what is the conclusion from all these remarks? In the end, we may conclude that the best approach to corporate criminal liability requires answers to a series of far deeper questions for which evidence may be thin on the ground. Is the public declaratory nature of the criminal law necessary to encourage better corporate behaviour and that of senior managers, or are civil and regulatory regimes just as or even more effective? Is a narrow interpretation of criminal liability in fact in the public interest? In my opinion, society should not criminalise a person, including a company, when there is no criminal state of mind. Nor should Parliament water down the test of what is criminal to reduce the number of failed prosecutions against companies. It is not a principled way forward, simply to stop the media from shouting a misinformed headline that those at the top have got away with something or a corporation has been let off. Unless there is actual criminal conduct, accompanied by the requisite mental state, I do not believe we ought to be criminalising behaviour. Regulation is one thing, criminalisation another.
Thank you very much, Amanda. That's incredibly thought-provoking, and now we're sort of moving into the sort of question and answer session. So, Gaynor, if there is sort of any questions, what I was proposing to go through was really to touch on some of those contextual bits that you spoke about first, and then moving through to your views in relation to where we're at now and where we should be going, as they may be seen as quite sort of principled and not pragmatic. So I just want to talk through some of that. But Gaynor, if there's any questions that sort of fit into that sort of time scale, please throw them at us as we go along. But the first one, really, Amanda, I just wanted to ask you about is, obviously we've talked about the UK position. So does how are other jurisdictions across the world dealing with this? I know that you've got plenty of experience, as do we, with the sort of US position and so on. And some of our audience may well do. But again, the US, any other bits of the world, how are they dealing with it?
Yeah, well, the US, of course, has vicarious liability for corporate crime, and it makes the job of the DOJ and the SEC extremely simple when it comes to prosecuting corporates. And I think it's made a completely different landscape for crime, actually, financial crime in the United States to what we have here. And that may, in fact, be part of the problem that the Serious Fraud Office suffers from, is being compared to a jurisdiction with a completely different test and a completely different level of funding.
And just following through slightly on that point, because it touched on where you were positioning yourself towards the end, which is that you shouldn't be altering the criminal laws to make it easier to prosecute companies in order to achieve that result. But obviously, if the findings of the Law Commission or if the government's view were ever to be, let's move to strict liability, let's move to the US position, companies will be liable for any benefit that they make from any action by any employee, whoever, wherever they may be. Would you be fundamentally opposed to that?
Yes.
And
I can answer that one very quickly. Can I explain why?
Yeah, no, absolutely. I was just going to say exactly that. On what basis, and what about the attitude of international parity to get a similar standard to this? So those are the two follow-on bits for you to address in one.
So the reason that I'm against it is because I don't believe the criminal law should be used to castigate behaviour where there's no fault. And what vicarious liability does is to say there's no fault by the corporate, but you're liable nonetheless, and you're criminally liable. I completely agree that we should have vicarious liability as we do for civil, but I don't think that's the case for crime. And in fact, my view is that if crime ought to be where there is the marrying up of a certain act and a certain state of mind. And what vicarious liability does is to remove the state of mind entirely from that equation. So that's the first thing. Secondly, I don't believe that just because America has got what I consider to be the wrong test, that we should be, in the interest of international parity, we should be going that way. Could I just mention that there are a couple of nuances in Canada and Australia in relation to corporate liability, which the Law Commission is considering, and that is where there is, and I'm speaking generally, I won't have the test entirely right, I'm afraid, but where there is some fault of some description or some blame to be laid at the corporate's door for the fact that the conduct has happened. So it is not a vicarious liability model. It isn't exactly a failure to prevent. It's a bit similar in a sense to sort of consent, connivance and neglect, if you like, by a director, although it is in the terms of the corporate itself. And I can understand where that's coming from, because it is reflecting some sort of corporate failing in its arrangements. I think one of the big things that occurs to me about what's difficult about this, and although as you say, in a sense, it's a principled approach that I don't want things to be dealt with piecemeal, and actually, in one sense, it is principled, but in another, it's pragmatic. I don't think corporates, particularly SMEs, should have to deal with a raft of all sorts of different requirements, depending on what the statute is that they might be falling foul of. I think one ought to be making things easy for people to understand the law and comply with it, because generally speaking, most businesses want to do the right thing.
So just following that logic through a little bit further, let's say the introduction of a failure to prevent offence, companies are used to it. There's been the Bribery Act, there's been the tax issue in relation to the Criminal Finances Act. If those were, say, scrapped and then a failure to prevent financial crime were brought in, and that the financial crime elements would encompass, say, the regulatory requirements of adequate systems and controls, of dealing with sanctions, data protection, tax, money laundering, fraud, bribery and corruption, all within it, do you think that would be something which incentivizes that behaviour, conglomerates all of the policies and procedures that are required in one place, and therefore makes it easier for companies to not have to look at lots of different pieces of legislation, but have one overarching failure to prevent financial crime? So a number of questions rolled up into one there.
Yeah, I mean, I think one of the issues is really a fundamental one about whether this should be the criminal law or whether it should be regulatory. And if you think about money laundering just as one issue that corporates all have to deal with, reporting money laundering if you're in the regulated sector, and thinking about it in any event, whichever sector you're in, the burden actually on the state in trying to wade through everything is so enormous that it's almost not functioning. And what worries me is that if we put in place something which puts even greater burdens on a frankly completely overwhelmed criminal justice system, with very little investment of any real gravity for the Crown Prosecution Service, the Serious Fraud Office, it seems to me that's the wrong way round. And one of the attractive things about the FCA and the regulatory regime for those that are under its auspices is the fact that it's partly paid, it's partly a business expense that they are there. It's got not just a sort of a function of wrapping people over the knuckles when they get it wrong, but it's there to assist and advise. And that's one of the issues that the Serious Fraud Office got itself into hot water with many years ago, a couple of directors ago, when it was kind of positioning itself in that same space. And now we have the exact opposite with the Bribery Act, where the guidance, now sort of 10 years or so old, is so general that nobody really knows whether what they've got is the right thing. So I feel that there would be a much better outcome for people if there was some kind of regulatory regime or regimes that they were able to get advice from, as well as a sort of disciplinary side to it.
Well, just dealing with that that bit, does that not introduce potential uneven applicability of the effectively what ends up being a punishment to those that are regulated and have regulators in place who therefore impact much more on the financial services industry. And we've got Gaynor on the line as well, who will no doubt be concerned about more regulation coming her way, and others that are considerably less regulated, such as those in the oil and gas sector that we have also got on the call. So what do you think about that sort of unequal standards being applied to different businesses, particularly when those operating in very high risk jurisdictions like Africa, Asia, and so on in the oil and gas industry may have just as much impact upon society, if not more, than say financial services irregularities?
Yeah, I'm not for a moment suggesting, if that's how I came across, I certainly was not suggesting there should be sort of areas of life that don't have a regulator now and should just carry on getting away with it. That's not what I was trying to say. What I was actually trying to say is that I'm not sure that criminal prosecutions are the way forward. I think it would actually make much more sense to have more regulators and less prosecutors in terms of corporate conduct, because I think actually it impacts the people who are involved in it in a much more direct way. It's quicker, it's more efficient, it's of greater assistance to the industries in terms of helping them to get the right balance between things. And actually, I mean, obviously we do need to have criminal sanctions for bribery in order to simply comply with our OECD responsibilities, don't we? But whether that's necessarily true, I mean, to take another example actually of a jurisdiction where the complete opposite is the case is, I don't believe France has any corporate liability at all, and Germany has limited. So, you know, we're talking about, in terms of the financial sector, so we're talking about perfectly decent regimes where they have a regulatory framework which works probably just as well as ours, if not better.
And then what about, just sort of leading through from that, in terms of the FCA's recent actions of having twin track regulatory proceedings running side by side with regulatory investigations, running side by side with criminal investigations? And obviously we've had two slightly different outcomes, one in the Credit Suisse tuna bonds case, which ended up being dealt with on a regulatory basis. Certainly in the UK it was dealt with by the criminal prosecution in the US, and then we have the NatWest case, which effectively went down the criminal route and is due to be sentenced shortly. So what's your view about the regulators then, who are doing what you're saying, which is taking a regulated approach, but in fact they're deciding to use their criminal powers because they feel they need to have the extra chops and the greater message that sends to the market? So what's your view? Should they have those powers? If the mute that person, Gaynor. Thank you. Sorry, Narendra, could you put yourself on mute there, please? Thank you.
I'll try to mute everyone, Patrick, just so it's easier.
Okay, as long as you don't mute us. So yeah. What's your view?
I mean, it's an interesting point, isn't it? Because and it comes back, I think, to what I was saying a bit earlier, which is an assessment that there's a declaratory part of the criminal law which is absent from the regulatory, and I'm not sure I agree with that. Actually, if the media chose to report what's happening with regulation in exactly the same way as they do with crime, which in fact for NatWest I don't suppose it makes any difference. And of course we know with DPAs that there is a difference, isn't there? If you need to be on a list and a conviction is sort of death to being on a list for future contracts. But that aside, seems to me that it's simply a way of understanding what it is that you're trying to achieve, and which is why I think the media has something to be there's an important role for the media here.
And then the DPAs, you just sort of mentioned them there, and I can sort of put my cards fairly on the table that I'm very much in favour of the Bribery Act, very much in favour of increased criminals. So I'm on a diametrically opposed end of the spectrum to you, partly because I was involved in bringing in the legislation and the guidance, but in particular in relation to DPAs, which is effectively a pragmatic criminal settlement process in order to avoid the stringencies of the usual criminal law. So in many ways it was to try and get around the problems which one faces with strict, beyond reasonable doubt proof of corporate criminal liability, and having something a little bit more flexible to deal with that with a lower standard. What's your view just generally as to whether that function of justice, of bringing in legislation which effectively takes something outside of the scope of the normal criminal process, whether you think that's a sensible movement, or whether you apply your more principled approach in relation to that as well, that it should be the same criminal standard and the same settlement process as other things?
I don't think that actually. I'm afraid we're going to have to agree.
Oh no, we're vociferously agreeing.
I think there is a place for DPAs, but my concern actually is if the point of a DPA is to save a prosecutor from resources and the uncertainty of an outcome, and if it goes down a route of typically relying quite heavily on an internal investigation that is done in good faith, but by somebody who has an interest in the outcome, the corporate,
not independent,
it isn't necessarily going to help to get a proper picture to start off with, a proper foundation for individual prosecutions that follow. And so to my mind, I think it's interesting that in America, they started off prosecuting corporates because it was easy with vicarious liability and not really pursuing individuals. And then there was a bit of a sea change and they started to pursue individuals as well. We have gone the other way around. We started off with individuals because corporates were so hard to prosecute. And what I think the DPAs may have done as a system is to skew the picture and the way in which prosecutors consider that their case is and should be run, and it isn't helpful. And the other thing that it certainly doesn't do is save resources, because if you have the corporate and the individuals in the same trial, which of course is what they tried to do with Barclays, but if you had that and you didn't have the DPA having already been agreed, and then the individuals being prosecuted, what you end up with there, frankly, is a situation where the SFO or the CPS saves no money whatsoever. And that, to me, is one of the really positive things about the DPA system, which is to limit the use of resources, the time that's taken, and this just looking at it from a prosecutorial position, and ensuring certainty of outcome as best you can. That those all seem to me to be, frankly, in the public interest. What doesn't seem to me to be in the public interest is marrying that with all of the uncertainty, all of the resources, all of the time that it takes to prosecute the individuals who have the trials that are following.
Well, is that an issue with the DPA system, or is that an issue with the SFO's analysis of what facts have been presented to them by the company? Because if the system is that you're meant to present true facts, surely if you then mess up the trial of the individuals afterwards because you've assessed the case wrongly, is that not a problem with the SFO as opposed to a problem with the DPA system, the process?
I think it's very difficult for a prosecutor who has got an beautifully packaged internal investigation report and underlying evidence presented to it to ignore it and start again from scratch. And indeed, there is a question about whether it should. But what it will not do, however good or bad the prosecutor is at doing their job, what it will not do is save resources if you have to totally ignore it.
Just challenging you slightly on that point before you move on to the next one. Assuming that one gets an enormous financial payout as a result of the DPA penalty, and go on. Colin, I think that might be you.
Could everyone go on mute, please? Thank you.
So just on that point, if the DPA, yes, agreed in 4 years in the Rolls-Royce case, in an Airbus case, then let's say in one or other of those, if people weren't all dead, as is exclusively the case in relation to Rolls-Royce, which is curious to those who represent those who are alive. But in any event, putting that to one side, if there was
entirely mortality, though.
If there was to be a prosecution of individuals afterwards, and the case lasted a further 3 years, taking up to a standard 7, yes, there is that cost going through it, the additional cost, but that would be offset by the DPA penalty, so it'd be a net gain, assuming it's not a very small penalty. So do you not still view that there is somewhat of a time saving, certainly for the company, and on balance with prosecution costs being paid and with the DPA penalty coming in, that it's actually there will be cost savings and significant cost benefits to the Treasury as a result of the DPA process?
Well, maybe in principle. Not sure that's exactly how it's worked out.
No. I'm not saying justice should be driven by the amount of cash that can be generated at the end of it, which is a criticism of the old confiscation system, that it was skewed towards confiscating assets so that the state could retain some of them as opposed to compensation.
Can I make another point, which is that in one sense, one of the real problems as well is that individuals do not get any money back if they're acquitted. They've had all of the cost, not just to their lives, to their ability to work, actually sometimes even to run a bank account whilst they're under investigation, waiting for a prosecution. And then they're acquitted and they or someone on their behalf, and even if it's an insurer, has paid out hundreds of thousands of pounds for something where actually they come away with no conviction. And sometimes it's not just, oh, they were lucky at all. They shouldn't have been prosecuted. And for me, that 7 years is inexcusable, actually, on a human scale.
Well, and certainly in terms of DPAs, because we helped draft the legislation at the time, and it was never envisaged by us in drafting it that there would ever be a time that individuals would actually be positively named, shamed, and then there being no ability to amend the agreement afterwards when they were acquitted, as happened in the Tesco's case. So certainly that was something which I'd never envisaged happening. But just one final point. I see that Gaynor sort of waiting there to mute us immediately. So just
you're gonna have to be quick because it's 1:28:59.
Anything else in terms of individuals and how they should be prosecuted better by the SFO, since it seems to be every DPA, not a single prosecution successful of individuals. What's going wrong?
I mean, I just question, if one comes back to the point of corporate responsibility for what's going on for the corporate gain, and that's part of the issue. I mean, that certainly was one of the things in Tesco, is that the individuals were not shown to have gained anything. I mean, not even a bonus. So in a sense, one's got to ask oneself whether the individual prosecutions are in the public interest. And even if you think, as the prosecutor, that there's sufficient evidence to prosecute. So I think the DPA may, of itself, embolden a prosecutor perhaps to think things are stronger than they are.
Well, we could go on speaking for the rest of the evening, but I know that you have a further engagement that you need to get to, which really ends us there. But it's been fantastic interesting and a great sort of overview of the corporate criminal side, the individual side, the SFO, and numerous other issues. But I'll thank you very much from my behalf, and I hope we've answered many of the questions that were coming through in the way that we've gone through it. But I'll hand over to Gaynor in case she has anything further to say.
Thank you. Yeah, thank you both. I mean, that could not have been a more pertinent subject for the lecture, I think, certainly for me, and I think for many of the audience as well. And I was certainly struck by some of the things you were saying about challenges that we have around the cross-jurisdictional nature. So where you're subject to multiple jurisdictions, regulation, legislation, and that can be a real challenge. So yeah, thank you so much to both of you and for providing that lecture. It was very interesting. I don't think we've had anything in the chat. No, we've got some thank yous coming through, but no actual questions. So before we go, I did want to say just a couple of minutes. We've got one really important thing left to do. So as many of you will already know, in recognition of certain key individuals' role in supporting and championing and underscoring the importance of the employed bar, BACFI founded a fellowship award a couple of years ago. And this year we are proud to present the award to someone who has absolutely provided outstanding service to and consistently championed the employed bar throughout their career. The recipient this year was called to the bar by Gray's Inn in 1972, and after pupillage in Bristol, practiced at the South Wales bar, and then joined the government legal service in 78. Working first in the solicitor's office of Her Majesty's Customs and Excise and transferring to the SFO as a founder assistant director in 1988. In 1997, she joined the legal advisors staff at the Bank of England and then moved into a newly formed financial services authority then, less than a year later. This individual was elected to the committee of BACFI in 2000 and served as chair from 2010 to 2012 and remained on the committee until 2016. During this time, this individual has been involved with lobbying the BSB for clarifying the rules applying to the employed and unregistered barristers and tackling numerous unfair discrepancies in the rules between employed and self-employed barristers. She's been involved in many meetings that I've been in as well, and we've been very happy with her to have her support and to lend her voice. She is not shy in putting her view forward, which is fantastic. So this recipient is a bencher at Gray's Inn, and she continues to forcefully advocate for the employed bar, for which we're very grateful. So I'm proud this year to present the 2021 BACFI Fellowship Award to Tricia Howes, CBE. Congratulations, Tricia. I hope you're on. And there it is. Hopefully you can see it, your award. I can't even see, Tricia, whether you're there or not. So do shout if you are.
Well,
she was here, but she may have dropped out, Gaynor. I'm not sure.
Okay. Well, we'll follow up later with Tricia. I think someone's got their hand raised and wants to speak. Tricia, you're there. That's great.
I think Tricia might still be on mute. But I think while we're waiting for Tricia to unmute, Amanda and myself may both have to disappear off. So Tricia, while you're unmuting yourself, many congratulations. It's been a pleasure working with you over the years, both at BACFI and then also in the time after you were at the SFO when you effectively forced me to join and strong-armed me to join BACFI. So I blame you for the 10 years of servitude that I've done in the intervening period.
Okay.
Over to you, and good evening, everybody.
Yes.
Thank you.
My little helpers are trying to unmute me. Am I unmuted? No, you see, it's
Yes,
working.
you are now. You are,
Oh,
Tricia.
bless you.
Yeah.
Thank you, Gaynor.
Congratulations.
And thank you all very much indeed. I was frantically raising my hand. I've got you on my phone, and my phone is running out of juice, and I can't for the life of me get you on a proper picture. So I am extremely grateful. Thank you so much. And happy Christmas to everyone.
Very, very well deserved, Tricia, and thank you for all your support over the years. Very much appreciated. Okay, so I'm conscious that we're a few minutes over 7. So just in closing, I just wanted to thank everyone for joining, wishing you a safe and happy holidays, and a reminder that the next event is on the 12th of January, I think that's right. And it's going to be exploring solutions to pupillage problems. So Tricia, I'm sure you'll be there again to support that particular webinar.
I will.
Great. Super. And hopefully we'll see you all there.
And thank you to our speaker. My goodness, I know she's gone, but I was trying to make clapping noises, but I can't make it do that.
No, she's still here. We're just putting on our jackets so you don't see us moving ourselves to disappear off. But we're still here. So thank you, Tricia, and
thank you all, and happy Christmas.
Great to see you looking so well as well.
Thank you.
Okay, bye bye.
Thank you. Thanks, everybody. Look forward to seeing you soon. Thank you.